Minutes, please.
Thank you very much, Presiding Officer. First of all, I am grateful today to have an opportunity to discuss the work of the Delegated Powers and Law Reform Committee's inquiry into framework legislation and Henry VIII powers. The genesis of the inquiry was a genuine desire of the committee to look at the issue of framework legislation itself. We hoped by taking a step back from any particular bill with the detail and policy context, we would be able to look at the bigger picture. This was, we hoped, a way to slightly depoliticise the issue, recognising that framework legislation has been used by governments of all stripes over the years and not just in the Scottish Parliament. Indeed, the Chair of the House of Lords Delegated Powers and Regulatory Reform Committee, Lord McLaughlin, who we met on our committee fact-finding visit to London, compared the change in views in relation to framework legislation between being in opposition and also being in government as being akin to a Damascene convergence, with oppositions generally being against and government in favour of legislating in such a way whichever political party is in charge. Now, though, of course, we also recognise that there is genuinely held concern by some members in this Parliament about framework elements in bills which have come forward this session and a perception that these are becoming more common. So we set out to examine a number of key questions, including, first of all, whether framework legislation can be defined, secondly, whether it is indeed becoming more common, and thirdly, also what might be done to improve scrutiny. This was for both framework primary legislation and framework powers being used to make secondary legislation. In seeking to explore these questions, the committee was indebted to the thoughtful and interesting responses we received to our work. As the Chamber will know, we heard directly from the conveners of both the Finance and Public Administration Committee, Kenneth Gibson MSP, and also the Rural Affairs and Islands Committee, Finlay Carson MSP, and I'm pleased that I believe that Finlay Carson is speaking in the debate this afternoon as the convener of the committee. We also heard from other legislatures across the world, including from colleagues across the Commonwealth Parliamentary Association. As members know, I value the work and engagement of the CPA very highly. The committee was also greatly helped in its work with views from key stakeholder organisations at the heart of Scottish policymaking, leading academics and think tanks, and also eminent legal bodies. On behalf of all the committee members, I'd like to thank everyone who gave their time providing the committee with written responses and speaking with the committee both informally and also as a witness. While issues relating to delegated powers may not be widely understood or discussed outside of the political, legal and policy bubbles, the level and quality of the engagement clearly demonstrates just how important scrutiny of delegated powers actually is, and should impress upon all parliamentarians the need to carefully consider delegated powers in the context of scrutinising a bill. I will repeat the comment that I have said in the Chamber in the past, and I recommend that every member spends time on the Delegated Powers and Law Reform Committee, as it clearly does increase the understanding and appreciation of how legislation and how our Parliament work. In delegated power, the Parliament is giving away the power to create law in a certain area. Achieving the right balance, ensuring powers are only delegated appropriately and that appropriate safeguards are in place, is an important undertaking, and we are glad to see that this significance is understood by many colleagues and also stakeholders. There's been a lot of discussion about what we mean by framework legislation, and during the evidence session on the 21st of January with Finlay Carson and Kenneth Gibson, Mr Carson during the session highlighted the difficulty perfectly as he alluded to two different definitions of framework legislation. This highlights the key challenge that politicians face when it comes to framework legislation. And after listening to stakeholders, the committee concluded that while there might not be a single definition, and that even with a definition there is still scope for reasonable disagreement and grey areas as to whether a provision in a bill meets it, it's possible to set out what framework legislation is. We concluded, therefore, that it is, and I quote from the report, legislation that sets out the principles for a policy but does not include substantial detail on how that policy will be given practical effect. Instead, this type of legislation seeks to give broad powers to ministers or others to fill in this detail at a later stage. Now, as Parliament... Sure?
Martin Whitfield.
I'm very grateful to Stuart McMillan giving way on that point, and I compliment the committee on the report. With regard to the definition of framework legislation, do the committee agree that actually a definition, however flawed, is still very valuable when we come to look at the other steps with regard to scrutiny of framework bills that may be necessary that differ from other bills?
Stuart McMillan.
Yes, but I think the fact we managed to get to some type of definition I think is an indication of that. But we also genuinely recognised how challenging it was to actually get to a definition too. And certainly some of the evidence that we heard was conflicting, understandably. So as parliamentarians, we think most of our colleagues will know a piece of framework legislation when they see it, but nonetheless we hope by setting out our understanding of it, we can help to inform debate. And it's also worth acknowledging that the Scottish Government has noted in its response that this description reflects the broad consensus of views amongst academics and also practitioners. And as to the frequency, the committee heard varied views once again. Now, there's a general acceptance that the occurrence of framework legislation is not diminishing, but without a universal agreed definition or a single way of counting framework legislation over time, it's not possible to give a definitive answer. But on balance, the committee considers that across jurisdictions it's likely the occurrence of framework legislation has increased, taking the 1932 report of the Donoughmore Committee on Ministers' Powers as our starting point, and that this trend seems to be increasing. Now, indeed, speaking of the Donoughmore Committee, which was established in 1929 and reported in 1932, it was reassuring to know that we are not the first parliamentarians to concern ourselves with the issue of ministers' powers. Certainly, we are not going to know whether this committee's report is going to be considered in 93 years' time. But the age of this report into what is substantially the same subject does speak to the fact that this is not a new issue or one peculiar to Scotland. Now, in terms of scrutinising bills, the committee agreed that its own preference, wherever possible, is for the detail of legislation to be spelled out on the face of the bill, to allow for transparency, for proper democratic engagement, and also so that stakeholders and parliamentarians can engage with and scrutinise solid proposals. Now, that said, the committee recognises the need, in some cases, for primary legislation to provide flexibility by allowing for laws to be updated without requiring further bills. In such cases... Sure.
Stephen Kerr.
This might be an unfair question to ask the convener, but he said that dealing with framework legislation made Scotland no different in terms of our parliamentary experiences. But does the structure of the Scottish Parliament, which has some unique features, does that make us more weak in terms of scrutinising the secondary legislation that comes about because of the nature of framework acts?
Stuart McMillan, and give you the time back for the intervention.
Thank you, Presiding Officer. So obviously I am speaking today on behalf of the committee, and I did touch upon my comments initially about the trying to look at this to depoliticise elements of the issue that we're discussing. So I'll have my own personal views, and I'm happy to speak to Mr Kerr about them afterwards. But in those particular issues, we didn't go into that level of great detail with regards to the functions and the structure, really, of the Scottish Parliament. So, but we can have a chat after. That's not a bother. So I think certainly the report sets out in detail the steps which the committee supports been taken by both government and also fellow parliamentarians to actually help to try to strengthen the issue regarding the primary legislation delegated and also the power and subsequent secondary legislation being made under it. Now, such steps include the use of the so-called super-affirmative procedures for subordinate legislation and also overarching justifications being set out by the Scottish Government in instances where it decides to take a framework approach. Now, finally, the committee concluded that while it expects to see so-called Henry VIII powers, and that is powers which allow for primary legislation to be amended by secondary legislation, appropriately limited in scope, it considers them a necessary, efficient tool when used suitably. Now, at present, it is generally content with the drafting of most Henry VIII powers in the Scottish Government bills, and that they are subject to appropriate parliamentary procedures. And at this point, I will put one personal point on the record, that I personally don't like the issue, or the idea of Henry VIII powers, but I do recognise and I do agree with what we as a committee found unanimously. But, Presiding Officer, to conclude, I hope that the committee's report proves to be helpful to the Parliament and beyond in the longer term, and the basis for an interesting and informative debate this afternoon. And I thank my committee colleagues for the way that they worked throughout the whole inquiry, and I look forward to hearing contributions from other members also. I also want to put on the record my thanks to the committee members, to the excellent clerking team. My thanks on behalf of the committee members to the excellent clerking team and the legal advisers of the Delegated Powers and Law Reform Committee. Their assistance during this inquiry certainly was invaluable, and I know that we all appreciate everything that they have undertaken to help us in our actions. So with that, Presiding Officer, I'm happy to move the motion in my name. Thank you.